Good morning, everybody. Jay Womack, founder and CEO of Inflated Workforce Solutions. Thank you so much for joining us today. Our webinar will begin in just a few minutes. I appreciate y'all sitting on hold. While we're here waiting for everybody to jump on, I want to give a special shout out to our existing clients that are here with us today. You are proving to your entire workforce that safety is your number one concern, it's your number one priority, and we appreciate that because we are very, very good at delivering training for safety, for orientation, for ongoing corrective action, and you obviously have taken the jump into the company right now and you're using it, you're saying that your people are valuable to you, and that's exactly what we want, that's what you want, that's what your people want to hear. So we do have all the answers. We know exactly what we're doing in web-based training. We've been doing this for 15 years, but I have a special offer today for our prospects that show up. We'd like to offer you a 30-day free trial using our system completely. See what it's all about. See if you like using something like this. You know, remote training has jumped to the forefront of the world. In the last 90 days, the world has shifted, it's changed. Remote training, we are the experts. We know more about remote training than virtually anybody in the entire, world, universe. So I want to offer the 30-day free trial. Time offer is limited. Yeah, we can't make this go on forever. I wish we could. I'm even going to throw in a CSR rep, a client service rep that can make this thing hum for you, get user activity up on the system, because that's the key, get your people to use the system. I don't care how many bells and whistles you've got, if they're not going to use it, it's not going to have an impact for your company. And at the end of the day, that's what we're all about. We want to see your top line and bottom line improve. We want to see your safety record improve. That's what we do, and we do that better than anybody out there. Thanks for sticking with me. In the meantime, it's what you came for, it's the webinar. So Mark, if you're ready, I'm going to hand it over to you.
Good morning, everybody. This is Craig Hart here today. And as Jay mentioned, we are doing that trial of our program for those of you who are new and unfamiliar with our system. Let's go ahead and get everyone to open up your chat windows. This is a participatory event. To open up your chat on your menu bar there at the top, click on the More button with the three little dots. You'll see a box that says Chat. Go ahead and open that up. This is a great way for you to ask questions of our guest speakers today, or of Mark and myself. And also, while we're getting started here, go ahead and fire up in your chat box who you are, where you're from, and where you're joining us from today. We'd love to see that. All right, now today everyone is joining us for Before the Storm, Enterprise Risk Management and Tort Reform. This is an exciting webinar that we've got for you all today. We have had several speakers in the past dealing with the issue of nuclear verdicts and strategies that your organizations can employ to protect your companies. There is not one magical bullet, though, to solve this problem. And I'm excited about this webinar today, Mark, because this is a tactic that we have not talked about before: enterprise risk management. How are you structuring your organization before the accident ever even happens to make sure that you are protecting yourself? And I'm super excited about what we're going to learn today. Another use of our chat here today will be to ask questions of our guest speakers. We've actually had some folks email them in before, which we have never had before, Elle and JW. We've never had someone ask us questions before the webinar has ever started. So we've got some interested folks on the line, but please put those in chat. We do have a member of our team, Lindsay, who is monitoring chat there, and we'll make sure that we get your questions asked if they are not addressed in the presentation of the information. Again, my name is Craig Hart. I am with our marketing operations team here with Inflated Workforce Solutions. Joining me this week, and what seems like every week we've become a duo here, Mark, is Mark Rhea. He is a former industry executive with over 35 years experience, more than 30 of those with Frozen Food Express, who I'm sure is a name that many of you recognize. They're a big frozen food hauler that works all over this country. And he is now an advisor for companies within and without the transportation industry to help give them guidance on where things are going. And he's having a chance to talk with him before. He's plugged into a lot of cool cutting edge stuff in regards to autonomous vehicles and expanding training. So Mark, always a pleasure. It's wonderful to see you.
Absolutely. And today, as you mentioned, we're kind of wading in a new swamp here with JW and Elle. We all lose sleep over the risk. And of course, we take a risk every time one of our tires roll down the road, of course, and we spend a lot of time with the driver and the equipment. But today we're also going to include what I call looking at the multi-dimensional freight transaction, the broker agreements, the owner-operator agreements and contracts, the corporate structure and the corporate veil that's out there, and some of the things that you might not have considered that certainly contribute to risks relative to the nuclear verdicts that are out there everywhere. So today is really going to be an interesting conversation. Looking forward to JW and Elle telling us what to look for. How can we prepare pre-litigation for some of these traps that are out there?
And everyone, we do have two guest speakers with us today from Taylor and Associates out of Winter Haven, Florida. We have J.W. Taylor and Elle Slattery. This is a dynamite team here, folks. They both have different focus items. J.W. is more of the trial litigator. You'll find him in the courtroom once the bad thing has happened. And Elle is positioned more to be your consultative voice before the fact. How are you structuring your corporation? How are you structuring your contracts so that you're addressing liability? And we're very excited to have you both here today. Elle and JW, thank you so much.
Well, thank you, Craig. Thank you for that introduction, that kind introduction. And we're certainly happy to be here. Looking forward to, most of all, hearing from your listeners and seeing what their thoughts are. But you hit it right, Craig, to kind of kick things off. We're talking about before the storm. And we'll all say the storm is what? Being in that courtroom. And I don't want to be in the courtroom. We have trial attorneys. We have great insurance defense attorneys that do those things. Our job is what? To keep you out of that courtroom. However, when you're there, are you in the best position you can possibly be in order to deal with these nuclear verdicts or these claims? And that's what we'll be talking about today.
Excellent, excellent. Hi, Elle, anything you want to add to that?
Yeah, I'm very happy to be here, really excited to talk about this. This is what I do all day, every day. And we have to be honest, the storm doesn't even just start in the courtroom itself. It's when you first get that email, when you first get that call, you realize there's a problem. It throws everything out of whack. It can take months to resolve, even before you may see the inside of a courtroom. And we want to keep that away from everyone as much as possible as well.
Excellent. Excellent. Yeah, looks like we have quite a diverse group joining us today in terms of what they haul and where they're from. Looks like we have coast to coast audience with us today, which is great. So let's go ahead and get this underway here. Here we are.
Well, you mentioned, Craig, the nuclear verdicts. And when I'm dealing with this topic, and good news, listeners, this is not another nuclear verdict presentation. That's not what's happening here. But we've all heard many of them. We all know what nuclear verdicts are. But what was interesting to me as we lead into what we're trying to outline here is that we found some information that's shocking. And you may have seen this before, but if you're a trucking company, if you're a motor carrier, and you're involved in a crash, didn't say anyone's hurt, didn't say it, the average cost of that is $172,000. Didn't say you were negligent. With an injury, that cost, whether it be attorney's fees, verdicts, and those types of things, with injury, jumps up to over $300,000. Fatality, over $7 million. And we keep looking that up. I mean, every time I see this, right, Elle, I'm like, is that right? But it is. And I think about the cases that I handle. And most of the time, I'm sitting as owner's equity. I am the general counsel for all of these different motor carriers or logistics company. And I think back over the cases that I've dealt with and the cases that I'm handling now, even a few minutes ago. And that's about right. That's a couple of years ago, this information. Go to the next slide. Here's what it is today with fatality. Yeah, that number is real. In the Southeast, as everyone knows, has heard these nuclear verdicts in Texas as well. The one that we'll be talking about in a moment, and even here in Florida, and I don't even know. I don't believe this number contemplates the $411 million verdict here in Florida against a onesie-twosie, a small trucking company. And if you haven't checked that out, you should find out what really happened there. And we don't have time today, but feel free to hop on my website and you'll see an interview with FreightWaves on what really happened there. But the point here is $411 million. Last check, that's a lot of money.
No, that's actually a great webinar. I've sat through that before. Their team member, Kristen, another member of Taylor & Associates, participated in that with FreightWaves. It's very informative on that subject.
Yeah.
Definitely something you should be aware of, but you should also be cognizant about what happened on the part of the owner-operator involved that resulted in that large judgment.
JW, I had a quick question.
Telling.
Yeah, on the $17 million fatality verdict, I know there's hours of service issues, there's driver or equipment. Are there corporate structure and maybe broker agreements that contribute to that $17 million?
Yes, and yes, and yes. So, and the good news is, Mark, we're going to be talking about some of those things. Let's go to the next slide, and I think I can help answer. We threw this Georgia, again, there's the Texas cases as well, but this Georgia case is kind of what you're talking about there. What happened? How did we get to this place? So, hey, Elle, tell us a little bit about this Schnitzer case, and I'll jump in as well.
Yeah, this is essentially the case where everything that could go wrong went wrong, and it touches on everything that you just brought up. This was a case where you had a truck driver who actually crossed the center line, ran headfirst into a car carrying two grandmothers, a mother, and two children. They were all killed at the scene. This massive verdict was handed down against the company. And part of the reason was because of their faulty corporate structure. The truck itself was working for Schnitzer Southeast, which was the private carrier for Schnitzer Steel. But the driver signed a contract directly with Schnitzer Steel, which was this parent company, just completely rich with assets, lots and lots of money. And they were directly tied into this lawsuit because they found that there was no corporate separation between these two entities. So not only are you able to get at these massive, massive amounts of funds and assets, but you also now have people up there on the stand that have never worked in trucking in their entire lives. These are executives that solely work in manufacturing and in steel. So you don't have any kind of expertise to answer what plaintiff's counsel may be bringing at you. Beyond that, they had real issues with documentation. And you bring up hours of service, which is the first thing that we always talk about, because believe it or not, in 100% of cases where nuclear verdicts are handed down, there are hours of service and documentation issues. There hasn't been a single one that's come down where that hasn't been a problem. In this particular case, there was a lot of confusion and discrepancy about whether the driver had been on vacation directly before this accident occurred or whether he had been working. And the logbooks contradicted each other. And so they weren't able to say with any kind of certainty how much sleep he had gotten, how many hours he had been on the road previously. And that was seen as highly, highly negligent in the courtroom.
Yeah, Elle, that's a great summary. And the point we're trying to make with this particular nuclear verdict is that what really went wrong, the things we could have controlled, we did not. Schnitzer did not control. And improper structure equals improper documentation, right? If on your application, you have the parent company doing the application, the DQ, and you say, no, this is just a motor carrier action. That's that piercing the corporate veil issue that keeps everyone listening awake at night. And so that's what happened here. And, you know, as Elle said, lots of things went wrong. We were trying to act like a trucking company. We didn't know what we were doing in that situation, but certainly defense counsel didn't help at all. I actually watched the closing, and for some unknown reason, defense counsel thought it was a good idea in closing to say that the mother that was driving, it was really her fault and she could have avoided this accident. And so should have never been to trial in this case. Certainly should have done some things before the storm. And that's what we want to talk about next.
Excellent. And I know, Mark, you and I have harped on several events now that when you engage lawyers in the defense of your organization, take the time to make sure that they are trucking lawyers, they understand this industry. It sounds like from what you shared with me, JW, about this earlier, this was a lawyer that was connected to this transportation group through their insurance company, but was not a trucking defense lawyer and directly contributed based off of jury feedback into them coming to their decision. And so you want someone that knows how to present you accurately and correctly in the courtroom. So it's super important.
That is very important. And let me say this, Greg, there are a lot of good insurance defense attorneys out there that that understand these things. And so that's very important. But hey, listen, the jury came back in 45 minutes and said 280 million. Ouch.
Ouch.
So what we really wanted to talk about today, using that example, is how do we mitigate this? How do we step in before the storm? And I have 5 different things here. And obviously today we can't go through the ins and outs of all these, but I'll throw them out for you there, Craig, is understanding the tripartite relationship. And maybe this is the first time many of your listeners ever heard that. Because Craig, as you were talking about earlier, is you have the insurance company that insures your motor carrier. You have the defense counsel hired and paid by the insurance company to defend the motor carrier. And that attorney owes the insured motor carrier a duty of loyalty and all of those things as attorneys do. But who's paying that defense attorney? The insurance company. And that attorney has probably lots of work with that insurance company. And so there's a dynamic there that's difficult. And again, our insurance defense attorneys do a great job. But the tripartite relationship is when general counsel, and that's what we do, general counsel steps in and says, hey, I'm paid by the insured directly. My job is to what? Protect owner's equity in these types of situations. So that relationship is really important to have in place. We're able to get things done, get things settled. Look, I spent this morning talking to plaintiff's counsel in a double fatality. Yes, I'm talking directly to plaintiff's counsel in a very, very bad case. And I'm going to get that case done because of the relationships we built there. Very important. Step 2, which we will talk about as we move along, is the corporate structure and the contract management to mitigate against these types of claims. Step 3 type discussions would be talking about when a crash happens, and you've probably had presentations, Craig, on that. Giddy up, get stuff done. Now is the time, right now. So we would talk about that. Early resolution is really important. It's what we found in mitigating these nuclear verdicts. It doesn't get any better. And so if you can get a case resolved quickly, fairly, then that's the thing to do. And that takes, again, on the tripartite relationship, I'm very involved in pushing defense counsel, pushing the insurer to get this done. Don't come back when medicals have inflated and now we got to deal with it 3 times what we would have, 4 times, 10 times. And we will talk at the end today about getting involved. All your listeners today, getting involved because things can happen. There's some good news that we'll deliver toward the end of the presentation on tort reform and curbing these lawsuit abuse.
Excellent. Now, I just want to throw in here for those of you who have joined us on previous sessions, We have talked about that step 3 in great detail, what you need to gather at the site of an accident, how quickly you need to do this, what are the different groups that need to be involved. We even have training in our system about that as well. And then early resolution, we had a great session with our guest speaker, Peyton Inge, who talked about deposition and discovery and how mastering that absolutely can get that early resolution knocked out for you before it ever gets to trial. So we do have some resources available. Obviously, we will be working with JW and Elle to get them back again for parts 1, 3, and 4 again, because I'd love to hear them talk about that. We're going to talk about 2 and 5 today.
So enterprise risk management, maybe it's a new term. We hear the term risk management often, and we hear it so much that we kind of fly by it. But I had a risk manager tell me many years ago that a lot of the problems that we see in managing risk is that we, meaning motor carriers, brokers, we think about risk two-dimensional, and it's not. It's a three-dimensional issue. And you can create collateral damage by doing this and not seeing that. And so, Elle, why don't you kind of take us through some of the enterprise, which means your operation.
Sure.
Your enterprise inside, by the way, the supply chain. Go ahead, Elle.
Correct. And it's really a comprehensive and connected approach to understanding not only your operations, but also how you fit into the bigger picture of the industry. Because unlike some other industries, you have your internal operations that you are doing in your own corporate entity. Then you have the relationships that you may have with your customers, with your brokers, with your shippers, with those kind of parallel entities. And you have coming in from over here, government regulation and compliance that you need to be aware of. So you need to take really, like you said, a three-dimensional approach to understanding how these things fit together and making certain that you are structuring yourself and being aware of all of the components so that you don't have any exposures that you are unaware of lurking in the background.
And Elle, that sounds so elementary, and the listeners will probably go, well, of course. Why would we say this? Because when we do go in and restructure companies, sometimes after a bad case, hopefully not, but oftentimes, or on insurance renewal, I'm going in, I'm restructuring. This isn't done. It's really not. And it's not articulated. And the left doesn't know what the right's doing. And
I mean, there's both internally, there can sometimes be a lot of assumptions made where you believe that you're there every day. You are in it. Your boots are on the ground. So you feel that everything is understood, not only among your employees and your coworkers, but kind of internally in your systems and your documentation. When you're inside of it, sometimes it's hard to see what isn't being done. Not only that, you are dealing with people outside of the industry, outside of your internal operations. If you can't explain concisely and clearly who you are, what you're doing, and how you do it, so much can be lost in translation in those communications. And that's where you can really get into some trouble.
Yeah, we find those things out with deposition. Let's go to the next slide. Yes, so some key principles, and we're going to show you some more structure.
The first thing we'll always try and do is make certain that if something happens, you are in the best position and have the best structure to protect the assets that you have. Usually what we're talking about with this is don't put everything in your parent company. Don't put everything in the entity that holds your equipment, because all of that is valuable. And if you're in a situation where an attorney is looking at your structure and they say, aha, there's money here, there's value to be had here, you are far more likely to end up in a courtroom than settling well before that happens. So first we'll look at structure, we'll protect the assets that exist. Moving forward from there, we kind of try to look at the operations and optimize and secure up what's going on there so that that's never even a potential.
Yeah, that's right, Elle. And you look at these kind of bullet point thoughts, and don't put your owner's equity in the motor carrier authority. Okay, let's not do that. And so there's ways structuring to do that. Hey, listen, we do understand the dynamics between a motor carrier and your customer shippers. We understand they only deal with asset-based. We hear these things, but we can separate out the motor carrier from the assets, the brokerage operations from the motor carrier. Yes, we can. And you guys recall when we found out that you could actually do that, MAP 21. Craig, that's a whole nother presentation that we can come back to. But MAP 21 says, yes, you can put both your authorities in the same entity, the motor carrier, the broker, dual authority. It's a bad idea. And it's a bad idea on many fronts. And insurance underwriters don't like it at all because, as one of these points says, we can't tell if you're acting as a motor carrier or a broker. And what's that going to mean to plaintiff? If you're acting as a motor carrier, why? That's where all the liability is. Because as I often say, you got drivers out there every day making $1 million decisions. All right, so this
is really where it all starts. This is the heart of it all. This is the first thing. And as you said, it seems elementary when you think about it. But anytime we are working with a new client or when we are revisiting some of our existing clients, we go back to laying out in clear and simple terms the structure, the operations, and the connections between all of the parties. And you would be shocked what we find when we actually go through this step by step. I would say there's almost always something that is getting missed. And unless you have it in front of you and you're looking at it in detail, it's hard to see because everything is moving at such a pace and everything's going along. And until you have that massive exposure, until you have that accident and someone's going through your files, until you have that DOT audit, and someone's looking through all of your documentation, you don't see it and you're unaware of it unless you've taken the time to actually map it out and plan.
And now I'll add to that because I'm sure we have a lot of sophisticated motor carriers and folks on as attendees. Oftentimes, we go through audits and we live our life and quite frankly, motor carriers grow up, that things just happen. Why did we do that? I don't know. Well, let's not do that anymore. That's a conversation I have often. But if you look at this flow chart here, and this is obviously just a hypothetical, and this one's more complex maybe than some of our attendees today might have, but you may not have a parent corp, and you don't have to have a parent corp, but there could be reasons for that, including buying leverage and things like that. But what I want to show, if everybody will come down and look at the ABC Motor Carrier Inc., or the motor carrier, and that motor carrier has internal assets. Where are they? Well, for instance, the terminal, the real estate. Should that be in the motor carrier authority? Absolutely not. So where do you put that? You put it in real estate LLC. So those types of things. Equipment. We know that equipment may be encumbered. Equipment may have little value, but that's not true of everyone. But certainly an equipment leasing agreement, I should say a third-party equipment leasing company, a sister company, if you will, is a great place to buy, sell, manage your equipment, especially, for instance, if you're a food-grade tanker. Those tankers are very expensive and they hold their value, those types of things. And you say, well, okay, I get that, and I could do a lease back to my motor carrier or to third parties, and absolutely. But whatever value is in that equipment company sits over there. Does it have a motor carrier authority? It does not. And so it doesn't have motor carrier exposure. In fact, it has the benefit of something called Graves Amendment that protects it from these types of ownership in regards to auto liability. So important information there. And of course, as you look at the ABC motor carrier, and this one has 25 power units, but you may have owner operators. We all know the exposure with owner operators, and especially recently with AB5 and all these other misclassification issues. We want to make sure what? We have a really good, if you're an interstate motor carrier, really jam up, well-written independent contractor agreement that complies with 49 CFR 37612. And so we want to do those things. But Elle, as I talk about this, and we do this and we get the right independent contractor agreements in place and doing the right things. But what we found is there's lots of trouble in the intra-state world dealing with owner-operator drivers, right?
Yeah. It's something that, because it doesn't have that definitive outside regulation coming in from the federal government, it does often get overlooked. But now that some of those federal regulations are really trickling down and being codified into state regs, things, like ELD regulations, hours of service that are more and more mirroring what you have on a federal level, there's more and more exposure with making certain that you have these solid agreements and documents in place if you're an intrastate operator. And the other place that having this clear picture, this clear understanding of who is doing what and how they're doing it, the other place it helps, it's not just, protection from these liabilities. When you are going in for your insurance renewal, being able to paint this picture and saying, we've taken a look at what's going on. We understand the potential liability, and this is what we're doing to deal with it. This is how we're structured so that we don't have these massive exposures. We're a good risk. You are going to find underwriters to be a lot more receptive to what you're doing and responsive in giving you insurance that you can afford that keeps you moving forward if you can present something like this.
Yeah, Elle, I heard everyone just say, insurance I can afford, there's no such thing. But that's well said. And we do these presentations and these visuals about the operation. By the way, it needs to really reflect your operations. It's pretty powerful when you can say to an underwriter or to a plaintiff's counsel, hey, here's who we are, and my ABC broker has no exposure. Look, it's separate. Here we are. And by the way, look, I have my broker motor carrier agreement in place. Look at the indemnifications. Look, that triggered coverage. All of those things, which by the way, you have to trudge through that at some point, discovery, right? Right, Craig, which apparently you guys had a presentation on that. Hey, we show up with our clients and with companies that are properly structured, boom, here it is. It's pretty impressive. And you know what it is? Like, Craig, I think you and I were talking, we're not the droid you're looking for. Yeah, there's easier targets out there than this company. And Craig, hear me, Mark, hear me on this. I was doing it this morning, speaking with plaintiffs' counsel. They know that we know what we're doing, meaning my motor carrier knows what they're doing. And it results in cases getting resolved, and resolved, hear me, inside the limits. Isn't that key? So we could spend 2 or 3 days, Craig, just on each of these pieces from the warehouse agreements and if you have those operation third-party agreements, broker motor carriers, but each of these agreements are vital. Each of these agreements should be in place and it should be properly written.
No, I think probably there are some people on the call with us today that are like, oh, well, this isn't my concern. I'm not that big of an organization. And I know we've got the 25 power unit group on the screen right now. I wanted to bring up a real life example for those of you that don't think that this kind of sophisticated layout applies to your organization. But RCX Solutions is a group that has been in the news recently this year as well as last year. They had 22 drivers, 7 staff in their office based out of Arkansas. The owner of the motor carrier also was running his own brokerage. He had a load he needed to have moved. They had a leased trailer from Extra, which I'm sure some of you work with as well. They contracted with an owner operator in Texas. That driver ended up going across the median, struck a truck. The driver was killed. The individual that was struck suffered third-degree burns, did live, but had catastrophic injuries. the owner of the motor carrier thought, oh, well, I contracted with this owner operator. That's not on me. And the judge and the jury came back and went, you ran the brokerage, you ran the motor carrier, you are the motor carrier. This was all done under your authority, and hit them with a $23 million judgment. This 22 truck company got a $23 million judgment. Now, they got that knocked down as being excessive charge to 7.5 million, but there's probably, everybody on this call would agree, they don't want to pay 7.5 million either, 6.5 million after the 1 million their insurance kicked in. So it could be that your organization may just be this lower right corner, but you still have these agreements in place. You still have these contracts in place that in some cases have been in place for years and have not been reviewed in any reasonable amount of time to make sure that they're still current, that they still protect your organization. But I recommend everybody go through this exercise, break out the units of your business so that you can properly look at, okay, I've got this group over here. This is where all my trucks are at. It's also where all my terminals and all of our physical locations are at as well. Is that the smartest move for our organization? And is there anything above our parent corporation, as it were, that this all funnels up to, that like the individual group that you mentioned at the beginning of the call, they were contracted with the parent company at the top, which means all this stuff underneath is then fair game. And that's crazy. So you don't want it to go past this box here in the middle as ABC Motor Carrier. So what are you doing with your specific companies to identify how you were structured so that $280 million judgment does not come back on you? So if you think you're too small to take a look at this, you are wrong. You are absolutely the right size to look at it.
So well said. We say it this way: the best practices for a 300 power unit company is the same best practices for a onesie, twosie, 5, 10. What is it? 90-something% of all cargo moved in the nation is moved by trucking companies with 20 or less power units. Yeah. So that's who we are. That's where we are. And those best practices need to be applied. And by the way, this particular Texas one, if I'm not mistaken, Elle, this particular one that Craig's speaking of, I think they just filed bankruptcy. I think they shut the doors.
Correct. They tried to keep going. Their insurance went up 300%, and the business dried up. So they could not continue to do business. So we don't want that to be anyone on this call.
And the other thing to keep in mind is that because this is what you do all day, every day, you can sometimes lose sight of how complex even the smallest operations are if you are involved in transportation. But I promise you, if you try and explain what you do to someone outside of the industry, they pick up that it's very complicated right away. There is not anyone involved in the transportation industry that doesn't have 3 or 4 or 5 things going at once, because it's very interconnected and extremely complex.
Hey, yeah, Elle, people, other attorneys ask us all the time, what is it you say you do? what is it that you actually do? Because no one understands it. We're talking about within our profession. And so what I like to say to our attorneys, and Elle will shake her head on this one, is every day, everything we do is like a law school exam. That's how complex it is: regulatory, case law, operations. However, back to the point we want to make here is, and Craig, I like the way you said it, we need to be able to articulate what you see in front of you, whatever you really look like. And you need to get someone involved that knows how to ask the right questions, because you don't know what you don't know. But we've seen it not only from the insurance side, when it comes X date, it's time to renew. We get all of that, talking to underwriters who do it all the time. But I also talk to claims, whether it be auto liability, whether it be cargo. So we know what's coming. We know what that looks like. And then, of course, the catastrophic claims that we deal with, what your listeners may know as over limits cases. And we have a lot of those going on, and we've been very successful in getting those done inside the limits.
And, once you have this in place and you have a handle on this, if we move to the next slide, the next step is, so you have your structure in place, you know who you are, you know what you're doing. Now you have to make sure you're actually doing it that way. And that is a crucial next step that often gets missed. You think to yourself, I have this wonderful employee handbook. I have these safety policies. I have these vetting policies. I have all the contracts in place. But what happens when that's not actually the way things are operating? Sometimes it can be even worse to have the correct document with all of the correct terms if you aren't doing that, because that's exhibit A. That's what they are going to hold up when you are in the courtroom saying, but you knew you should be. It's right here. You have it written down. You absolutely knew that's what you needed to be doing. So you also have to have a comprehensive program for assessing your operations. And this in front of you is actually the way DOT audits are done. This is the way the FMCSA looks at what your operation is handling and how you are functioning. So if you know this going in, when you are looking at what you're doing and making policies and speaking to your employees, your drivers, your coworkers, you can handle this on the front end because it's not a mystery. It's not, you won't sit there unknowing what they're going to ask or expect of you. This is what it is.
No, this is awesome. And I think that you are now at least the third lawyer in 4 months that we have had in front of our audience, talking about policies, procedures, doing what you say you're going to do when it comes from how you maintain and communicate with your drivers, how you hire and qualify people, because the first thing that's going to happen is if they see you acting outside of policy, and you see that as step one here on this circle, it's a very easy argument to make that, if you had followed your own policies, that driver who behaved badly or who found themselves in that situation would not have been on the road in your truck. That accident would not have occurred. So your negligence contributed to this accident. It caused this accident by making it, the pieces come together. So
Craig, as we move to the next slide, Elle may have been the third one to say that, but she's the coolest one so far.
I agree.
So I really want to hear from Elle, and I think it's important for the listeners because we want to make sure we get through all of our slide deck. But Elle, I think the listeners want to hear what's going on post-COVID with what we're seeing in the interventions and those type of things.
Right. And for a lot of you, I may not be telling you anything new. You may already be very aware of this. During the COVID pandemic, most of these audits did not stop. They did not say we aren't going to do audits. What they said was we are going to do them remotely. We are going to do desk audits. We aren't going to come out to your facilities anymore and walk around and have you show us what's going on and get the rundown directly from you. We are going to ask for a very precise sampling of your documentation, and we are going to sit and review it. And they found that this was very effective. And so they're like, now that things are kind of getting back in person again, they aren't going to do much in person anymore. It's more cost effective for them to do it remotely, and they're getting what they need. They're seeing what they need on paper.
And the bad part about that, Elle, and I know some of the listeners here, in fact, I've been through some DOT audits with some of the listeners on here. I saw some names going across, and very, very knowledgeable safety director. But there's something about having that safety director sitting there face to face with that auditor, and both of them knowing, okay, this guy's legit. This is a good actor, as we call it.
Yeah, you don't get the chance.
You'll get that, right?
You don't get the chance to advocate for yourself when you are just handing over a set of documents. So those documents have to advocate for you.
There you go. You said it. So the documents must speak, and they must speak clearly. Let's go back to the Schnitzer case, all of those things. But remember, these are big companies. These are companies with lots and lots of resources, and they're still not doing it right. And so we want to make sure they thought they were. Okay, let's go on to the next slide.
Now we are running a little close on time, so I'm probably I know this was a bit repetitive, so I'm probably going to skip past this one. But this one, people need to know about on the call. Everyone, these are your takeaways for today's conversation on how to protect your organization.
Yeah, know your brand. And we want to be able to tell our story visually and articulate it to our underwriters, to plaintiffs' counsel, and those, can you do that? If I were to grab one of your attendees and go, tell me. Could you tell your story? Could you represent it? The key players and their roles, the follow-up. You got to revisit this narrative of here's who we are, here's why you want to underwrite us. Look at our structure, look at our contracts and those types of things. So can you do that?
Yeah, and you know what? As soon as you put something into place, anytime you put something into place, immediately calendar a follow-up on it. Don't put on it, do it right then, because otherwise it's going to slip by and you aren't going to be certain that it's actually being implemented correctly.
Yeah, follow-up's key, and getting the right players. Get people on their team that know what they're doing. Get the DOT, the safety director, get the CPA, get the attorney, get the folks in place that can bring the knowledge that they bear on your narrative.
Now, someone had a question for us when we were talking about trucking lawyers, and I know there's not a special trucking lawyer merit badge that you have completed that qualifies you to be a trucking defense lawyer, but if someone is trying to identify a good lawyer for the transportation industry, are there things they should be looking for that lawyer is doing or has done?
Wow, what a great question.
Yeah.
And there is no certification to be additional certification, like for instance, a certified trial lawyer. Those things, you don't get that for transportation. However, we kind of call our certification the TLA, the Transportation Lawyers Association. That's a group of really good attorneys. Look, in this small world, talking about attorneys in transportation, in this small world, we all know who we are, and we know who the attorneys are. And so I refer out to good attorneys all over the nation. So I'll be a resource to any of your listeners. You need to know, hey, who do I hire in California? I know who that is, and I'm happy to refer that. But what have they done? Well, you got trial lawyers, you got corporate lawyers. So it depends on what you're talking about. I think trial lawyers, we want to make sure that they understand our business. On the things we're talking about today, they're few. Hey, listen, I tell Elle, I tell my other folks this, when I go and meet owners of trucking companies and I start talking about what we talk about, and I always, if I had $1 for every time I've heard this, I'd have a few dollars, but it's, hey, I've been looking for you for a long time. Why? Because that person, that owner does not have to educate us on trucking. We know it. And I'd say, Elle, please don't laugh too hard. The way I explain it is this, is we know what a jake brake is. And so, and that means a lot about understanding the operation. So to your person that questioned that, find out if they're in trucking, find out if they're in transportation. You'll know very quickly.
We'll have your contact information at the end of this presentation for everyone to write down, so that if you would like to visit with JW and Elle, they do work across the country, but they also have a network of individuals that they work with and rely on to protect trucking companies, and they can certainly get you pointed in the right direction. So awesome. All
So
right,
we're not going to spend a lot of time on this. I'd like to, but I will say, tort reform. Hey, good news. Things are happening. And I'm going to talk about today kind of two ways we reform the legislative and the tort reform system is case law. Well, Colonial Freight is a case that we acted as, we represented the American Trucking Association in this and wrote the amicus brief up to the court. And the good news is we won, and it set a precedent in this case where basically it says that, hey, listen, if you use a TA or a Flying J who fixes your truck, you're not liable for their actions. Yes, this is what we had to deal with. That's reform. Really big case I want to talk about, this Wilson Hart case here in Florida. And basically you had Wilson Hart going down the road in the big tractor trailer, and cameras all around, video, event recorders all around, comes to a complete stop. Lopez hits Wilson Hart from behind, kills Lopez. Summary judgment, right? Look, never left my lane. I came to a complete stop. I didn't do anything wrong. In Florida, which was in the minority of states, said, well, if there's any scintilla, any little bit of evidence, we can't give you summary judgment. So here in Florida, you can't get a summary judgment. And what does it do? It's driving up costs. Plaintiffs' bars using that to keep you in the case until you what? Sell for more. And that's what happens. But it went up through appeal, and it went up to the Supreme Court with a certiorari. A very important question is, hey, is video evidence enough? Did you not, Craig? Hey, is video evidence enough? Because plaintiffs did what? They got an expert and said, well, you might have changed lanes. And they found this witness. I think they might have changed. That's enough. And so the Supreme Court here in Florida said, we'll take that question. And by the way, maybe the question we ought to be asking is, do we have the right rule for summary judgment? Long story short, we now have the federal rule here in Florida for the standard for summary judgment. And so that's really going to be good for trucking companies. So, hey, heads up on that. Let's go to the next one. Florida, good news. We were just up there. I sit on the board of the Florida Trucking Association, and hats off to the Florida Trucking Association, Dr. Armstrong, and all the good folks there. The curbing lawsuit abuse, we don't call it tort reform because we wanted to have a fresh look at it. And we've worked really hard on that. Yesterday, the day before, I'll go through these quickly. Yesterday, we got signed into law, COVID liability protection. Good news, Craig, for your motor carriers out there in Florida, by the way, we have protection from COVID claims as long as what? And by the way, if you're not in Florida, still be doing this. Are you using good efforts to protect your employees? And if you are, then you have protection here in Florida under this Protection Act. Plaintiff bears the burden that you didn't use good effort, and also requires a doctor's note with reasonable certainty that the motor carrier's actions actually what caused the COVID injury or death. So good news. Thank you, Governor DeSantis, and hats off to his crew as well. And as we were up there in Tallahassee recently with all his folks and doing a fantastic job on that.
So what I heard from all that was, everyone on the call, I know that you are doing protocols to keep your drivers safe. You have rules in place about equipment and procedures. Make sure you're documenting all that. Make sure that that is in writing. Make sure that your drivers understand what you are doing. That sounds like this would be immensely helpful in this kind of a situation, because you can prove your positive efforts proactively. It's going to go a long way. So document, document, document.
Right, Craig. And as Elle pointed out earlier, documentation, corporate structure, those things must be visited and revisited. I bet you if we could raise hands in our attendees today, how many of you read your COVID policy? Wait a minute, is there one? All right. So big thing here is inflated medical bills. And what we've asked for, and it's we have a Senate bill and a House bill, and I've talked long about that, but here's what we're saying. Plaintiff's attorney, I'm a motor carrier. I'm not going to tell you whether your person's hurt or not. I'm not going to cry about the billboards anymore. Here's all I'm asking. Transparency. If it's a $20,000 procedure, you can't put on the damages board in front of the jury $200,000. I just want the truth. Craig, isn't that the right thing to do? This is where I actually have the right legislation to say that. You got to tell me the truth. And so it's here in Florida, it's still in the chambers. It's still being worked out. It's hard. We've used up a lot of political capital getting the COVID legislation passed, but that's in play. Contingency multipliers, that's in play. We got House bills, Senate bills on that. Litigation financing, we have House and Senate bills on that. And we could spend, we could spend a whole lot of time just talking about those things. Maybe that's a conversation for later.
Sure.
We spend just on those things. But here in Florida, that's happening. These things are being addressed, and we're going to stay on it. We're not going to give up. Hey, listeners, if you're not involved with your local trucking and motor carrier association there in your state, do it. And please reach out to me if you need contacts there. Texas is doing a great job. What you just heard me talk about, the inflated medical bills, the contingency fee multipliers, all these things. We have sister bills going on in Texas, and they're doing a great job. It's happening. And listen, motor carriers out there, if we're going to drive down insurance, If we're going to remedy these hellholes that the insurance companies do not want to underwrite in, you got to participate. You got to be involved in these things. You got to support it. And I know many of you do, and thank you for that.
No, thank you for that, JW. I know we'd had questions about that transparency issue about inflated medical costs from people sending them in. So, Anthony, I knew you'd get an answer, so I'm glad you waited. Appreciate that. So, but good things are in the works. As JW mentioned, what happens in Florida, because Texas faces similar challenges, is mirrored very closely. So, and those tend to be the more difficult areas, and then that spreads over to the less problematic markets or venues, if you will. So that is all good news. The COVID change is excellent. Mark, I know that you've been up to date on some of the stuff specifically for Texas. Did you want to give us a quick run? Because I mean, that's literally this week too that this occurred.
Yes, there's a House Bill 19, Senate Bill 17 that's in session. It's not been voted on yet, but it's certainly being knocked around, and its primary focus is inflated medical bills. As you know, a billboard attorney, if he gets a call and somebody says, "Hey, I'm hurt," they're going to say, "Don't go to the doctor. Call this number." Is their practice, and that number is a doctor that is in cahoots with that plaintiff's attorney, and it's a fairly common practice. And that legislation is designed to curb that, and I think hopefully we'll get some momentum and get it on the board, and we'll get that into action. I did have one quick question or comment from Elle on all, you know, that the slide that had all the multi-dimensional freight transactions and contracts that are involved and parties that are involved. Would it be fair to say that our plaintiff attorneys have a similar set of flow charts and understand the complications of these freight transactions? And you can assume that in the discovery phase, you're going to need to be able to produce those contracts to the plaintiff's attorney to comb through.
Yeah, I mean, they're certainly going to, and in discovery, sometimes what happens is they will ask a very broad question. They will say, you know, send us all of your contracts. So even if they don't know from the outset exactly what they're looking for, any good attorney, once they get those papers in their hand, are going to understand what they mean and what they can do with them.
That's spot on, but let me add something to that. When all that gets done, they get all the contracts and everything. To answer the second part of your question is, does plaintiffs' attorneys really understand it? Not really. I often sit through these mediations, and plaintiffs and everyone look at me and go, "Hey, JW, could you explain how that works?" And we can, and we do. And that's very powerful as well. But as Elle said, they're going to be asking for that information, and they're going to keep digging, and they're going to try to find that, that silver bullet on their side. But we are going to be able to explain, no, that's not a silver bullet, and here's why.
So a preview by your firm of those contracts and documents could certainly save you a lot of money.
It does, and it's not only in the litigation side of things, incredibly important for the underwriting side of things in the insurance.
Yep.
You come in, you show up with the right documents in place across your enterprise, managing that risk. You're managing the risk across the supply chain. We all benefit.
And the great thing within our firm, because we have a corporate side that really handles, all of these kind of contracts and structuring, and we have great litigators at our firm, we can collaborate. They will look at the contracts that I'm drafting and say, no, I saw this. They're gonna rip this apart. This needs to be different. So we have, the experience from both sides to be able to give you the strongest set of words, to reflect what your operations are, that someone's going to be able to look at it and say, yeah, no, you were in compliance. You were doing the right thing.
All right, I have a couple questions for you from our audience. Everyone, contact information is on the screen for both JW and Elle, so you can reach out to them after the fact. But JW, I have one question for you. This is one that our insurance folks tend to dance around. what are your thoughts on the likelihood of the mandatory minimum coverage increase from 1 to 2 million? Do you think that is something that we will see in the short term, or if that is still something that is a big question mark?
Yeah, so the answer is probably not short term, or however that's defined. Is there the possibility, of course, probability? I think we'll move that way. What are going to be the driving factors? Well, one, obviously the larger motor carriers don't have a problem with this, right? They're already 1x of 1, 5x of 1, whatever the case may be. And if you can't afford it, well, then that competition goes away, doesn't it? So, so there's that side of it. Then there's the side of, are we really protecting the public? This is plaintiff's argument. Are we really protecting the public? Look at all these verdicts and you don't have near enough money. I don't think that's a valid argument, but it's an argument that keeps getting sounded. So I think the legislature is going to continue feeling that pressure. And, you know, here's something, $1 million doesn't go very far these days. And so, so I would say there's a good possibility. I do not know the timing of that. The impact on the supply chain will be capacity, right? And the continued strain on capacity, because there'll be motor carriers that can't afford the premium for 2 million, 3 million. And lastly, shippers are asking for it. Shippers are asking for it in the contracts.
Yeah.
And that's going to be, maybe, oddly enough, I don't know if your listeners have thought of it, that may be the bigger driver.
That was exactly what I was going to say, is regardless of whether it's codified into regulations, practically, if everyone's going to expect you to have it, it doesn't matter whether the government says you have to have it or not. And that's a concern.
Excellent. All right, gang. Well, we're a little bit over, so I just wanted to thank JW, Elle. Thank you so much for your time. I absolutely, we could probably spend another hour talking about this morning and still not be where we need to be, and helping this audience understand everything that they need to have in play to protect themselves. I know we've had some additional questions come in. Feel free to reach out to Jay and Elle directly. I know some of you have asked about whether or not they operate in specific states. And they can certainly answer those questions for you, or get you plugged into one of the partner organizations that they work with and get you squared away. So I did see your question, Enrique. Good to see you again. Glad you're back with us. And then just as a reminder, would like to also, if you have questions for Mark or myself, feel free to use Mark's email address on the screen right now. And I do believe we have a poll question for those of you who are new to our organization and would like to learn more about our free trial that we spoke about at the beginning. Let me see if I can find that question. It is not allowing me to launch that question on the screen. Dun, dun, dun. Yay, technology. Please reach out to us, though, if you have questions about that demo. We would absolutely can get you details about that, and something that you can take advantage of. Risk-free, 30 days. You can implement a safety management system like Elle and JW discussed that provides you that documentation fallback for your training efforts, for your policies, procedures, and so forth. We would love to get those details into your hands. So feel free to reach out to myself, craig.hart@verticalag.com, or you can provide your details to Lindsay in chat, or Lindsay's email address. She can probably put that back up in chat for you so that you guys can email her directly as well. But otherwise, everyone, thank you so much for joining us today. Mark, it's always a pleasure. Elle,
Yep,
JW.
I did want to remind everybody next Thursday, work zone.
Yes.
I know they don't have work zone problems in the state of Florida, so just kidding. We all are struggling with work zones, so we've got a very good program next Thursday, same place, same time, on work zones and the dangers and hazards in our work zone. So.
And things that your organizations can do to prepare for that. That Work Zone Awareness Week is coming up the end of April. So we want to make sure that you got your ideas flowing now so that your people can be armed with information beforehand. So excellent. Excellent. All right, everyone. Thank you so much. Be safe out there. We appreciate you.
Thank you.
Thank you.